Great. Well, good afternoon. This morning, as I did the introductory remarks, I was pointing out that we wanted to focus your attention on a number of the major fact questions that are going to be being addressed throughout the weekend, and for you to keep your eye on ascertaining what type of evidence there is to support these. And we're going to have a full day tomorrow dedicated to that. What I want to do this afternoon is to start pointing out some of the legal principles that we need to be cognizant of in attempting to discuss the viability of a parallel case that will go along with the other case that is actually being done now by the other big law firms. Okay, that we talked about this morning, that the passing of JASTA may well give them the opening to continue to pursue their thesis, predicated upon the findings of the 9/11 Commission, supplemented by the 28 pages, and continue to dig in, trying to find out whether or not the Saudi government and other financial institutions are legally liable for what was done, if in fact the 9/11 Commission report as to how this all happened is accurate. As I pointed out this morning, the purpose of this week's gathering is to try to determine what the state of present evidence is and what legal theories that we have available to determine whether or not there is grounds for a parallel case pursuing a different theory of the case, and supplementing the range of defendants who have been designated by the other case to have some joint tortfeasors available. Now, I point out at the beginning of this legal discussion that I'm not here today to support or defend or to attempt to criticize any particular of the alternative legal theories that might be available. You've heard a few discussed here today, just recently with the panel, the discussion of whether or not the United States government officials in the FBI and the CIA and the other agencies that have been involved were simply incompetent, or whether or not they may have been more involved in some type of scienter or evil intent in actually being involved in setting up some of these Saudi dupes, has been talked about before. And you just keep in mind that there's the old adage in law that the people who are responsible for something like this would much rather be considered to be a fool than a knave. And that seems to be the nature of the debate partly going on now about what particular types of alternative theories may develop out of the evidence. But what I want to do this afternoon, I want to be able to direct our attention to a number of important legal principles, because one of the things that's going to be being proposed this weekend by the people who've been working at this for 15 years is that a specific law firm be set up, or a legal team be set up to pursue the investigation, the expert evidence, the evaluation of the legal theories, etc., to be the base of an operation to try to see whether or not such an additional supplemental or parallel legal case is going to be viable. And what I want to be able to do as sort of a senior, not so much senior statesman as a senior class member of the baby boom generation, who's been trying these types of cases for going on 50 years now, as it turns out, that I've been engaged in prosecuting and defending political cases, dozens of them over this 50-year period, these politically charged cases. And what I want to do is I want to set forth what might be considered sort of the 10 commandments that our people who are going to be considered to be part of this legal team need to keep in mind. and that you as potential laypersons who are participating and supporting this type of an endeavor need to keep this in mind, so that you will see as the legal team, if one is developed, what the principles are that they're following, that you'll understand and appreciate them. One of them has been touched upon a number of times, and what I'll do is I'll be careful not to wander off into too many war stories. You may know how trial lawyers are. They love to tell war stories about the various trials that we've been involved in, but I will share a few of them with you to dramatize some of the principles that we need to observe. One of these principles has been that whoever is being involved in supporting the legal team and who are working on the legal team, they have to be ready to be aggressively criticized by the mainstream media. Not just ridiculed lightly, but aggressively attacked. And I'll give you one particular example. In the Iran-Contra case, we at the Christic Institute had filed the Iran-Contra case back in May of 1986. And there was a dead silence about this. We talked to everybody about it. We talked to people at the New York Times. We talked to people in NBC News. We talked to PBS. We talked to people in Congress about it. There was dead silence on this until October 5th of 1986, when Eugene Hasenfuss was shot down by the Nicaraguan Sandinista government over Nicaragua in a C-123 flying weapons into the Contras in complete violation of the Boland Amendment that had been passed by Congress. And all that news hit the stands, and right away we were called, finally. People kept saying, listen, isn't that the thing the Christic Institute's been trying to tell everybody about? And so what happened is that the journalist community actually, who had said nothing about this, gathered together at the New School for Social Research here in New York City, or the Avenue of the Americas in West 12th Street. And they filled up a place the size of this with professional credentialed journalists in the room. And I remember that Leslie Coburn from CBS had undertaken to try to do a piece for West 57th Street on this. And I got up and I presented to the entire room of some maybe 300 credentialed journalists what we were saying at the Christic Institute about what was really going on behind the whole Iran-Contra crisis. That this wasn't some young individual renegade lieutenant colonel in the Marine Corps that had somehow gone around and recruited old retired military experts off the golf courses, outside of Washington, D.C., and happened to slap together this, slapdash weapons supply operation. This was a high-level, coordinated criminal conspiracy on the part of high-level government officials in the CIA and in the White House, being run directly out of George H.W. Bush's vice presidential office. And his national security advisor, vice presidential national security advisor Donald P. Gregg, was helping to coordinate this whole thing. And that he was the CIA case officer for Felix Rodriguez, who was running the Ilopango airlift out of Central America. And we've been telling everybody this. And so when we got done making this presentation, people's jaws were kind of hanging open in the room. And somebody stood up and they said, Leslie Coburn from CBS, do you believe that what the Christic Institute is saying is true? And she got up and she said, look, I'm just speaking for myself now, not CBS, but I can tell you I've looked into this and I believe that it's true. And there was this whole rumble went around in the room, and one of the journalists stood up and they said to Warren Hogue, who was the foreign desk editor of the New York Times, who was standing there on the forum with us, and they said, Warren, why hasn't the New York Times printed anything about this? And he said, gee, I don't know. And so one of the other people in the audience stood up and now made bold, stands up and says, look, would you give us your promise that you'll send somebody down to the Christic Institute to gather this information? And he said, uncomfortably, he said, okay, I'll do that. And the next week, he sends down a young fellow, like 26 years old, who was in fact a reporter for the agricultural section of the New York Times. And this fellow didn't even know who the FDN Contras were. He didn't even know who they were. So I explained the whole thing to him. I gave him all of the details of this, and I could see him writing like mad. Like he could see Pulitzer Prizes, dancing in his head. And so I give him the whole thing, and he goes back to New York. I was down in Washington, D.C. He goes back to New York, and 2 days pass, 3 days pass, 4 days pass, a week passes. I give him a call, and I say, Neil, what's the story? You know, you said you were going to do a story. He says, well, look, I got to come back down and talk to you. He comes back down to talk to me, and he says, look, I got a problem here. My editors at the New York Times tell me that that you're giving us information that's hearsay information. That you weren't there to see them unloading the cocaine. You weren't there to see them loading the weapons. You didn't see the weapons being handled. I said, okay, first party witnesses. So I took him around and I introduced him to pilots that were flying the weapons in. We showed him the end user certificates, the false end user certificates. We showed him the serial numbers on the weapons that were being smuggled. We talked to the pilots. We brought him in. They showed him the landing codes to land on John Hull's ranch. They gave him the secret code words you had to use to land on the. So he says, "Oh, this is it, Pulitzer. Here I come." And so he goes back to New York, and I don't hear anything. 2, 3, 4, 5 days, 6 days, 7. I call him again. I say, Neil, what's the story? Why aren't you doing it? He says, look, I got to come down and talk to you again. He comes back down. He tells me, he said, look, here's my problem. My editors keep telling me that if I'm going to write anything about this story, it has to be negative. It has to be negative about your investigation. It's got to be negative about what your assertions are that are being made here, or else I can't write anything. And so, you know, I was kind of dumbfounded by that whole thing. So I said, look, let me tell you an additional story and see if this will get you there. And I told him that after we'd done our preliminary investigation and prepared all the Iran-Contra case, and prior to our filing the RICO complaint, I had taken all the information over to see Scott Armstrong. Scott Armstrong was the head of the National Security Archives in Washington, D.C. He had been one of the chief investigators for Peter Rodino on the House Judiciary Committee investigating the Watergate burglary. That's how I knew him, because you know I was at F. Lee Bailey's office. We represented James McCord, the wiretap specialist in the break-in, and he's the guy that blew the whistle on Richard Nixon. Wrote the letter to Judge Sirica blowing the whistle on the plumbers and all that. So I knew Scott. So I go and I sit down with him and I give him all this information. And Scott says, this can't be true. This can't be true what you're saying. If this were true, I'd know it, he said. I said, well, actually it is true and you apparently don't know it. And so I think you should spend a few days checking up your sources and see what you think. He calls me back 3 days later and he says, Danny, come on over, you got to come over. So I went over to the National Security Archives. It was just 2 blocks from our office at the Jesuit National Headquarters. So I went over there. He sits down, he said, my God, he said, this is true. I talked to Cy Hirsch, and I talked to some other guys. They've all confirmed this. He said, look, here's what I'm going to do. He says, I'm going to go over to see Peter Rodino. He's still the chair of the House Judiciary Committee. They have the authority and the responsibility for bringing up articles of impeachment. And this stuff here that you're saying, these are impeachable offenses, not only against Ronald Reagan, George H.W. Bush, Donald Gregg, you know, Bill Casey, the head of the CIA, you know, Ed Meese, his national, and his other people. He said, this is tremendous. I'm going to go over and talk to him right away. I'll call you back in a couple of days. What I'm going to get him to do, I'm going to get him to set up a special select committee inside the House of Representatives and the Judiciary Committee, and he'll have me chair that. You know, he loves me, he said, because I was actually the one that got Alexander Butterworth to tell about the secret taping system inside Nixon's office. He said, so that's what really broke the whole Watergate case in the impeachment of Nixon and everything else. So he'll make me the chairman, make me the chief of staff for that committee. So I said, great. So I leave, and 2 days pass, 3 days pass, 4 days pass, 5 days pass. I don't hear a word. So I call up over there, and I get a hold of Tom Blanton, his assistant. I say, Tommy, what's the matter here? I haven't heard from him. He says, Danny, you got to come on over. So I go back over. I go back over and I sit down with Blanton. Blanton's got his head hanging down. He said, Dan, he said, you know, I feel like shit, he says. You know, he says, Scott went over and talked to Peter Rodino. He brought a copy of your complaint, and he gave it to him. Rodino sat there and looked through the whole thing, and Rodino said, he turned to Scott, and he said, Scott, this is terrible. This is outrageous. He said, well, if what's being said here in this complaint is true, why then, I mean, I've been telling my constituents for years that if they didn't like the way that American foreign policy was going, they ought to write a letter to their congressman. And if the congressman doesn't do anything, you ought to elect somebody else. Put another congressman in there. But if what's being said in this complaint is true, why then we haven't even been in charge. I'm not going to allow the United States Congress to investigate anything like that, is what he said to him. Okay? So I tell this story to Neil, this agricultural reporter from the New York Times, and he goes back, and the New York Times writes its first story about the Christie Institute lawsuit saying, Dan Sheehan is running around Washington, D.C. irresponsibly telling third-hand stories about aging congressmen. And that's all it said. You know, it didn't say who was the aging congressman, what was he told, you know, what was his response. You know, the chairman of the Judiciary Committee, they're basically representing the chairman of the Judiciary Committee as an incompetence mentis, you know, who you shouldn't even say anything to the newspaper about. So that this is the kind of thing that you can expect if you really start moving on this type of a politically charged case. And you're also going to be attacked not only from the right, which is totally to be expected, because they've drunk the Kool-Aid by the gallon that has been fed to them by the 9/11 Commission, but you're also going to be attacked by the sort of harder core left, because they're going to try to want you to file the lawsuit against the Central Intelligence Agency. And you ought to be filing the lawsuit against W. Bush. He's still alive. So is Cheney. Cheney's got a whole new heart. We may have him around for years. So we want you to sue him. You know, and we want you to sue the CIA as an organization. They don't have any kind of understanding, many of the people, about what the legal restrictions are on what you can actually do through the legal system and through the court system. Primarily because the court system has not been set up to do cases like this. The court system is set up by the financiers who set up the original federal government, Alexander Hamilton and other financial geniuses that wanted to have a centralized economic system and weights and measures and stuff for the colonies. And the fact of the matter is they're not set up to actually challenge the government itself, except that they've always known there's a risk. So they've set up the immunity statute, and it's not the foreign immunity statute that's just been set up as a restriction on a caveat on by JASTA, but in fact they have a general principle of sovereign immunity that no matter what kind of accusations you make about the government itself and officials inside the United States government, you cannot sue them unless they agree to it. So they have to agree to allow you to sue them, or you can sue them under the Federal Tort Claims Act. They've waived certain immunities with regard to regular common law garden variety tort claims, like, you know, if a U.S. Postal Office driver runs over some poor person in the street, you can sue them under the normal common law theories in their capacity under the Federal Tort Claims Act, but you don't get any jury. You can't have a jury. You've got to try the case to a federal judge who has been appointed by the president of the executive branch. You not only don't get any jury, you don't get any punitive damages. All you can get is your actual hospital bills or out-of-pocket costs. There are all kinds of restrictions they've placed on even the Tort Claims Act. So the bottom line is that you need to understand you're going to be getting aggressive criticism from the extreme left. We're going to be criticizing you for not suing the CIA and charging them with running lapdogs of the capitalist class. And so you have to be prepared for that. Now, you always also have to remember that the judges, any court that you're going to file this case in, state court or federal court, you've got to remember all of these judges are selected or appointed politically. You know, they're appointed by the executive branch. They are always appointed by a member of the executive branch who just happens to be the same political party that the judge is from, and that the judge has always been in that political party, has been an operant in the political party prior to their being appointed. That's how they got there. And so that virtually all of the decisions that they make are political. Now, that isn't pertinent in every case, like, you know, a dog bites man case or, you know, a domestic violence case particularly. But the bottom line is, as soon as you start to have a case that has substantial political implications, they're going to be making political decisions. And you get a whole bunch of these. That, for example, in the Karen Silkwood case that we did out in Oklahoma, we end up asking for discovery in the Silkwood case against the Kerr-McGee Nuclear Corporation. And it turns out that the first judge that we got, Luther Bohannon, absolutely refused to give us any discovery. We'd file subpoenas for documents. The Kerr-McGee Corporation would ignore them. We'd file subpoenas to have them come to take depositions. They wouldn't bother coming. We'd file motions to compel, and Luther Bohannon just completely ignored them, never ruled on them, wouldn't do anything. We finally started going after him in the newspapers and saying that he was sitting on these motions to compel, he wouldn't do anything. And so he finally orders a hearing, and we have a public hearing. He wanted to have it in chambers. We insisted upon having it out in open court. We come into the open court, and he starts raging at me, saying that, you know, that you're a magpie running off at both ends, as he actually put it. And so anyway, he started sort of slobbering on himself and getting crazy. And so that what we did is we filed a motion to have him recused, and he got recused by the 10th Circuit Court of Appeals. We got a second judge, Luther Eubanks, came in. Luther Eubanks was totally incompetent. I think I can say this now, only because everybody knows it. You know, that we were taking a deposition of Jackie Saruji, who was a woman who was writing a book about Karen Silkwood. In report, she came to the Congress and tried to get them to stop having any investigation about what happened to Karen Silkwood when she was killed on the highway on the way to meet with David Burnham from the New York Times to deliver a whole set of internal documents from the Kerr-McGee Corporation that showed that they were missing over 40 pounds of 98% pure bomb-grade plutonium from the facility. And she thought that it just meant that they were messy. As it turns out, what she stumbled upon, the MUF documents, the missing and unaccounted for records, is that the 40 pounds of bomb-grade plutonium was actually being smuggled to Israel by the American Central Intelligence Agency and the high-level officials of the Kerr-McGee Nuclear Corporation, because the Kerr-McGee, the Kerr of that was Robert S. Kerr, who was the chairman of the Senate Military Appropriations Committee. And so the entire operation was a covert operation to smuggle the plutonium to Israel, and they had to share that plutonium. Israel had to share the plutonium with Iran under the Shah, and then they had to share it with the Afrikaner government down in South Africa, and that we had exposed this. And the minute that we exposed this, by this time we were working on our third judge. We had a third federal judge brought in by the 10th Circuit Court of Appeals. And so we filed that information with him. And the minute that we filed that information with him, he called a special meeting saying that, look, the CIA has contacted me, and they're sending people out to see me on Monday morning. I wasn't supposed to tell you about this. They wanted an in-camera secret hearing with me to file a motion to dismiss the case, but I thought I had to tell you about it, so I want you here Monday morning. So I come into the court Monday morning, and there's Judge Tice, Frank G. Tice. He's up on the bench. He says, "I'm glad to see you here this morning, Mr. Sheehan." He said, "I've told you I'm going to have this meeting with the CIA people, and I know you don't agree with this. I know you're going to object. I'll put it on the record." He says, "But I've decided I'm going to have the meeting. You can't come into the meeting." And just then, Glenn Whitaker, the attorney for the FBI and the Justice Department, comes walking through the door with these three suits from the CIA, and they come walking in, and the judge goes into chambers with them, right? And then Cy Hirsch, the investigative reporter from the New York Times, comes rushing in the door of the courtroom. This is the Oklahoma federal courtroom, the courthouse that was later bombed in Oklahoma. They were in the courthouse, and in he comes, and he says, "Dan, what's going on? What's going on? I just got a word from my CIA sources that they're out here on the Silkwood case. What's happening?" So I explained the whole thing to him, all about the plutonium being smuggled to Israel, all the details, all the evidence we had about it. He said, "Oh," he said, "gee, they're never going to let you get at that." He says, that's like trying to find out who really killed Kennedy." I mean, this is the chief investigative reporter for the New York Times. And not only that, but he didn't print a word about it, you know, about what was happening in the Silkwood case. And then Judge Tice comes out on the bench after 15 minutes. He gets up on the bench and he says, "Well, Mr. Sheehan, you can be," on the record he says this. He says, "Well, Mr. Sheehan, you can be certain that it's sinister," he says, "but it's also most definitely secret." He says, "This is just a glass mountain that you're not going to be allowed to climb in this case. So I am taking judicial notice at this moment that you filed your count 1 in this case under the Federal Civil Rights Act, charging that Ms. Silkwood had had her First Amendment rights to meet with the New York Times violated. She'd had her rights to First Amendment rights to travel freely on the highway safely interfered with, and she'd had her home invaded, a violation of the Fourth Amendment right of privacy, planting 400 disintegrations per minute of radioactive plutonium on the food in the refrigerator in her house. You've laid out these claims that are a violation of her Civil Rights Act. But I want to take judicial notice here that the Federal Civil Rights Act was passed in 1868, immediately following the end of the Civil War. And I'm taking judicial notice of the fact that the Civil War was fought solely for the purpose of freeing the black race from slavery. And therefore, the Federal Civil Rights Act applies only to black people. And since you've not alleged anywhere within the four corners of your complaint that Ms. Silkwood was a member of the Negro race, I'm going to be summarily dismissing this count from the complaint. Dismiss the entire count on her house being contaminated, her being run off. Oh, excuse me. The part about running off the highway, being killed, her body disappearing for 48 hours, nobody being able to know where her body was. They finally found it 48 hours later in the morgue at the Oklahoma City Hospital. A Jane Doe tag on her tail or on her toe, with all of her internal organs completely missing. Okay, and that was not justiciable. That was not justiciable. Because that was under the Federal Civil Rights Act, and we hadn't claimed that she was a member of the Negro race. What I'm trying to say to you here is that to the attorneys that are going to be working on this case, you need to be prepared to understand that the judge in the case that you're going to be doing is not going to be your friend. That you're going to have another lawyer in the courtroom at all times who is there litigating against you. And so you're going to have to be prepared to do that. So you're going to have to understand also that they are not going to give you access to the federal rules of civil discovery just because the law says they have to. And that's what the entire rules of federal civil procedure were about, that were crafted. The chair of that whole committee was Shapiro, David Shapiro, who happened to be my professor at Harvard Law School on civil procedure, so I'm quite familiar with them all. But the fact of the matter is, they will not let you get at those rules of civil procedure. They will block you, they will resist you, they will ignore your motions to compel. So the fact of the matter is, you're going to have a major mass-based movement behind what you're trying to do. And you're going to have a full-time coordinator of the media who's going to be reaching out and putting the stories on the internet, putting the stories into all of the alternative media, going to try to get the major news media to report these things. You have to have a full-scale operation going. And you need to have a field organizer, a grassroots organizer that organizes out around the country and organizes task force and teams in virtually every congressional district in the country. The Karen Silkwood case we had during the Iran-Contra case that Sarah Nelson ran out of our office, our executive director, she ran the entire grassroots operation around the country. We had like 1,000 Christic action teams. Many of you may have been members of those. So that they were writing letters to the editor. If Oliver North showed up somewhere to go to speak at the Kiwanis Club or something, they would all come and fill the room and jump up and down and ask him questions. These are the kind of things that you're going to have to be prepared to do. This is not a normal case. Okay. Whatever the theory is that you come up with, which is an alternative theory to the case that has been filed by the other law firm. Okay, so you have to understand, and do not think that just trying to get another official investigation is going to solve this problem. If you get a professional investigation from the Justice Department, or an official investigation from the United States Congress, or any other type of question, that they are all political creatures. And that's why they're there. And they will undertake a political activity, and they will try to keep you away from this. And I want to call to your attention something that Gary Sick wrote. Gary Sick, Barbara Honecker wrote a book on this, but so did Gary Sick, who was the national security advisor for President Jimmy Carter. In Jimmy Carter's negotiations with the Iranian government, when our 52 American hostages were seized at the American embassy in Tehran. And Jimmy Carter, you remember, was trying to negotiate to get our hostages back. And during that negotiation, Gary Sick, Lieutenant Colonel Gary Sick, actually Lieutenant Commander in the Navy, he actually was his assistant in the National Security Council. And it became perfectly evident that somebody inside the National Security Council was leaking the information about the state of these negotiations to Bill Casey, who was the campaign chairman for Reagan and Bush, competing against Jimmy Carter for the presidential nomination in 1980. And we developed all the evidence to show that Bill Casey, and some evidence indicating that even George H.W. Bush, that may have gone with him on one of these occasions, had traveled to Paris, had traveled also to Madrid, and had met with representatives of the Hezbollah to negotiate with them to keep the American hostages, to keep them in custody until after the election in 1980. So that Reagan and Bush could win by showing that Jimmy Carter was weak and vacillating and couldn't really even get our own hostages back. And Gary Sick wrote a book about this afterwards, in the aftermath of all this, called the October Surprise, because a special prosecutor had been appointed to investigate all of these wild allegations that this had actually taken place. And the special prosecutor came in with a whitewash report, and Gary Sick wrote a really interesting piece in the conclusion of his book called October Surprise, in which he said basically that those of us who have lived in Washington, D.C. for 20 years or more have become accustomed to the various political scandals. An individual congressman is caught with his hand in the till of his campaign funds for using them for private purposes, or another senator is found to be a persistent womanizer and caught swimming nude in the pool on the Capitol lawn, and all of their colleagues rush in to excoriate them. And the news media flock in and reprimand them in a great celebration of showing how the system works and how they've called this person to account. He said, these are petty offenses. And there's another whole category of political offense, he said, which he said that, he says, there's another category of offense described by the French poet André Chenier as le crime puissant qui font trembler la loi. Their offenses so grave that they cause the very foundation of the law itself to tremble. And he said that we know what to do with someone caught misappropriating funds, but when confronted with evidence of a systematic attempt to undermine the very democratic political system itself, we all recoil in a general failure of nerve. Okay, and he goes on to point out that that's what happened with regard to the October Surprise. And he makes direct reference to the Iran-Contra case and how they completely backed off. All of the major political officials backed off from really pursuing what was going on in the Iran-Contra case. And in fact, you may remember that we finally got a special prosecutor appointed. Lawrence Walsh was handpicked, but only because Ed Meese ran out into the national media on October 25th of 1986 and said, "Oh, what do you know? Oh, gee, we found this young lieutenant colonel all by himself, ran off and ended up, selling tow missiles to the Hezbollah and taking part of the money and putting it into a bank account in the Caribbean to go to the Contras in apparent violation of the Boland Amendment." But fortunately, he's been fired now. But just to be sure, I'm going to write up a charter as the Attorney General asking for a special prosecutor to be appointed to determine narrowly whether President Reagan ever in writing specifically authorized the sale of tow missiles to the Hezbollah and the transfer of a portion of the profits to the Contras in violation of the Boland Amendment. And he figured that he would stave off the entire rest of the investigation by so narrowly defining what the scope of the investigation was. And the special panel for appointing special prosecutors of the D.C. Circuit Court of Appeals, all the justices of which had been appointed by Ronald Reagan or George Bush Sr., that they'd all been appointed by them, they end up selecting as the special prosecutor the senior partner of Crowe Dunlevy, the law firm that we beat in the Karen Soakwood case. They choose the senior partner of the very law firm that we knocked over for a $10.5 million judgment, the largest civil judgment in the history of the United States up to that point in time, and brought him in as a special prosecutor. Now, I was glad because he's one of the few people on the planet that knew that we were completely right, you see, because he already had experienced that the hard way. And so he did know that when we say something, you better bring it to the bank and bring your checkbook with you. So that we were the very first people that they interviewed, and we began to give them all of this information. And lo and behold, we managed to convert the special prosecutor to actually doing a real job, at which point the entire constabulary in Washington, D.C. turned on him and began attacking him and charging him with, you know, flying on first class when he went back to Oklahoma on weekends during his tour as the special prosecutor, and et cetera. So that you have to understand that the Republican and Democratic Party are joined at the hip. Not just when you come to the shore, and it is in all foreign policy, which is what we're dealing with in this particular case. But to give you another dramatic example, when we were closing in on them and getting all of this information revealed, John Kerry, who I had actually proposed to Claiborne Pell, the ranking Democrat on the Senate Foreign Relations Committee, to be the chairman of a new select committee to investigate all the charges that we made, that I went to see Tip O'Neill, Russ Hemingway, the head of the director of the Fund for an Effective Congress, a close friend of John Kennedy's, you know, recommended I go see Tip O'Neill. He called Tip for me. I went in and saw Tip O'Neill, the Speaker of the House, told him the whole story. He sent me over to the Senate side to meet with Claiborne Pell. And when Tip O'Neill said to me, he said, "Look, when you ask him to set up this special select committee, if the Democrats, if we win the Senate back in the fall of 1986," he said, this was in June, the first week of June of 1986. He said, in the fall of November of '86, we're going to have the election, and if the Democrats, we can win back the Senate, then you go over and talk to Claiborne Pell and get him to agree in advance that they'll set up a special select committee to investigate all of these charges. He's going to ask you who you think ought to head up that committee. You tell him John Kerry. He loves John Kerry. You know, we kid him that John Kerry must be his illegitimate son. He said he loves him so much. You know, Claiborne Pell thinks John Kerry is going to be president of the United States. And I said to Tip O'Neill, I said, that's funny, so does John Kerry. So I did. I went over and I recommended it to Claiborne Pell. He, in fact, as soon as the Democrats won, they set up the special select committee. We start hand delivering all this information to John Kerry. End user certificates, you know, tail numbers on the airplanes, secret code words, you know, witnesses, the pilots that we got to tell all about it, and they're overwhelmed by all of this stuff. And they actually put together a preliminary draft of a report from the Senate Select Committee on Terrorism and Narcotics, telling that everything that we're saying in the Iran-Contra case is true. We get a copy of the draft of it, so we know what they were getting ready to say. And then all of a sudden, I get a call from Russ Hemingway. And Russ says, Dan, I gotta talk to you right away. He said, look, I gotta tell you, I just this minute, came out of a meeting. I was meeting with John Kerry. He said, and we were having a private meeting, and in walks the Democratic senator from Michigan, Don Riegel, comes in, and he says, John, I gotta talk to you privately right away. And John Kerry, rather casually, says, no, that's okay. You know, Russ is fine. He can stay for the meeting. And Riegel says to him, look, I've just come from the leadership of the Democratic Party, and they have said that they've been approached by the leadership of the Republican Party. And they're saying that, look, if you all by yourself make a decision to drop this investigation of the whole Iran-Contra enterprise and the smuggling of the cocaine and the assassination operations they're engaged in, and that whole off-the-shelf enterprise that you're looking into, then and it's totally up to you. The Democratic leadership wants to make it clear it's totally up to you. But if you do decide to drop this, the Democratic Party leadership wants me to tell you that they will be very, very, very grateful to you personally in the very near future. And I said to Russ Hemingway, I said, what the hell does that mean? He says, that means the vice presidential nomination when Al Gore runs for the presidency in 2000. That's what he said to me. Now this is like in 1992, you know, right when Gore and Clinton are getting ready to run. So I mean, that's how far in advance these people on the inside know how things are being arranged. Okay. And by the only reason that John Kerry wasn't given the nomination in the year 2000 with Al Gore is because Al Gore was so royally pissed off at Clinton for having lied to him about the Lewinsky affair that he actually selected, instead of John Kerry, who he was directed by the Democratic Party leadership to make his vice president, he selected Joe Lieberman. Because Lieberman was the only guy on the United States Senate who stood up on the floor and chastised Clinton for lying personally to his own best friends about this. And that's exactly why Al Gore picked him to be his vice president. And you remember that Al Gore did not allow Hillary Clinton or Bill Clinton to make one single solitary appearance on behalf of his campaign during the entire campaign in the year 2000. Okay? And so I've lived this for 50 years. We've been in Washington, D.C. for 20 years. We've been on the inside of these things for a long time. I'm telling you, this is one major hill that you're talking about climbing. But we have climbed a few in the past, all of us together. And the fact of the matter is that this may well be the biggest hill ever to climb because of the type of theories that are being implied by some of this evidence that is being developed are so extraordinary that they qualify as one of these types of crimes that shake the very foundations of the legal order itself. And that's exactly what you're dealing with here. So I just wanted to give a few principles and lessons to the women and men who are going to be the legal team that are planning to evaluate this, investigate this, and to all of you out there, not only the people who fill the audience here, but the people all around the country and around the world that are listening on the internet. You know, that you, if you're going to support this operation, this undertaking, you need to be prepared for this type of a confrontation. And you need to not wilt in the face of this. And so you need to be extremely careful about who you select as your plaintiffs. Listen to me what I'm saying. You need to be very careful about who you're selecting as your plaintiffs. There's a complex operation going on here on the part of the American institutions attempting to buy off the families of the 9/11 victims, setting up an entire fund to pay them off, to get them to waive any claims that they have against anyone. There's a whole effort underway to deal with just laying it off onto this group of Saudis, possibly even some individual financiers of the Saudis if they can't avoid that. But they don't want to hear what this group is planning to talk about. They don't want to talk about the implications of this. Whether or not they're perfectly willing to be considered to be fools in complete incompetence, you know, in lying bold-faced about not having had any advance warning of this, but they don't want to talk about the fact that the Able Danger, a military exercise, was going on at the same time, Vigilant Guardian. They don't want to talk about the fact that somebody could have taken an opportunity to launch this attack right at that exact same time. They don't want to talk about any of that stuff because all of the implications of that require very high-level, very sophisticated coordination. And they do not want that talked about. Okay? So I'm saying, so you got to understand, if you select an individual plaintiff, that the forces that you're dealing with potentially here will go to almost any lengths to buy them off, to offer them everything that they've ever wanted and more, to buy them off individually. So you need to be very careful. You have to have people who are dedicated down to the very soles of their feet to get at the truth of what's happened here. And that they're not in this just to be remunerated. They're not in it for any personal advantage. So you have to be extraordinarily careful. In closing, I have to say, you have to be extremely careful about who you name as defendants. Because you need to remember that the naming high enough level officials are going to cause them to invoke national security claims. They're going to refuse to produce the discovery. The judges are going to go along with their national security claims. You have to be extremely careful. So you need to have, as consultants to your legal team, people who are experts at the particular trial court that you select, the Court of Appeals that has jurisdiction over that and who the personnel are on that particular Court of Appeals, and have experience in litigating appeals in front of that court. And you need to always keep in mind that this case that you're talking about is going to end up in front of the United States Supreme Court. You need to understand that. So you need to keep your eye on who those personnel are. You know, and no matter how much the media wants to keep on claiming that there's this conservative side and liberal side of the court, we know that that's not true. All there is a completely reactionary part of the court and a conservative part of the court. Okay? And it's not likely that Hillary Clinton is going to be appointing any major liberals, certainly no progressives. You know, so that you're going to have to craft this very carefully. And the mix is going to be a little bit different. Because Justice Kennedy may no longer be the swing vote to craft your case to pitch it to Kennedy and looking at his past decisions, etc. So you're going to have to do this very carefully. This is going to be extremely high level litigation, and you can bet that you're not going to have any big law firms lining up to help you. Okay. You're not going to get the Cahill-Gordon litigation firm coming on board. You're not going to get, you know, any of the big law firms coming to help you. You know, they will all cite conflicts that they have. That, oh, you know, we represented somebody from one of the potential defendants, you know, back 100 years ago. So the bottom line is this is going to be a major challenge. You have to gird yourself for this. You need to stay in direct communications with people who have knowledge about these types of cases, at least on a consulting basis. And what I'm saying is that the key is having the kind of support from the people that's absolutely indispensable in a case like this. So you have to develop the grassroots organizing, you have to develop your media campaigns, and ultimately you're going to have to, prior to the filing of your complaint, you're going to have to determine what the exact theory of your case is. You can't really go into a case like this saying, well, maybe they were dupes, maybe they were incompetent, you know, maybe this, maybe that. You may be able to do that, and, you know, if a Boeing 757 were to land only on top of your private house, you as a plaintiff's lawyer, you can sue the airplane company, you can sue the people that are manufacturers, you can sue the Pilots Association, you can sue, you know, the weatherman. You can sue anybody you want, and then you can sort of peel them away as the discovery unveils information. That isn't going to happen in this case. You know, you're going to get one shot at this. You're going to get one shot at laying in what the theory of the case is and who it is that did what to whom, and who was involved in the support network. And you're going to have to put that in front of them, because the judges are going to apply, just like the Seventh Circuit Court of Appeals did, a heightened level of scrutiny. A heightened level of scrutiny over the factual information that you bring in at the initial front end of this litigation, okay? And they're going to try to dismiss it under Rule 12b-6. They're going to say, well, even if you could prove what you say, there's a legal problem that you can't really get at this. Or they're going to say that it's ineffective in convincing us, the judge, that is, convincing us that you can in fact get the kind of court admissible evidence that you're going to need to prove every essential element of the claim, even if we give you access to civil discovery. You're going to have that to confront. You're going to have to gather this information. You're going to have to put it all together. You're going to have to cross every T. You're going to have to dot every I. You're going to have a huge mass support around the country. And you're working at that. That process is underway now. As the panel has said, there have been advances that have been made, even just recently as yesterday, that show that there's an advance being made in the progress on this. But the bottom line, in the last item I'll leave you with is, do not drink your own Kool-Aid. Okay? Do not drink your own Kool-Aid. You know, don't come up with some great theory that necessarily that Dick Cheney sat in the bunker and coordinated all this from a single-eye computer, and just because that happens to fit your own ideological predisposition. The bottom line is you're going to have to work at this thing from the bottom up, gather your information, discern the patterns, identify your defendants, identify your causes of action, then go after this in a big way. And once you start, you better not stop. You better not stop, you better not delay. You're going to have to go all the way on this thing. So that's just my advice from 50 years in front of the courts in this country. So that's my advice, I'm giving it to you for free. Okay?